Well, thank you very much for joining the first IUA Policy Wordings Masterclass of 2025. We've been very much looking forward to this series, and this is our first session in a series of 4. Now, across the year, we'll be looking at a number of different subjects. So we're starting today with the 2024 Legal Lab, Case Law Unravelled, a look back at case law and key developments over the last year or so. Then in July, we'll be holding a session on global insurance adventures, the passport to coverage, exploring the concept of global programs and key considerations. Then later on in the year, session 3, delegated authorities decoded, passing the pen in October. And then in November, the final session will be pollution perils across class exploration, where we'll look at pollution definitions and risks across a number of different classes. Now, before we get into the content today, a very brief reminder as to what the IUA is and what we're all about. So we're the trade association for the company market in London. So about 80 member companies that are active outside of the Lloyd's market, some of them active across both the company market and in Lloyd's. But there'll be lots of familiar names that you've got on screen there, many of the biggest insurers and reinsurers who are active in London. Now, one of our roles in representing those companies is actually to publish model clauses and wordings. They are templates which can be used by the market, they can be amended, or they can be totally ignored. And there are a number of reasons why we publish model clauses, but most of the time, I should say, it's due to member demand. And that could be because we've identified emerging risks, new legislation, perceived inadequacy in existing clauses, or we want to provide some alternative coverage options. Of course, market practitioners are still able to do what they've always done, which is to produce their own clauses and wordings and to use those. Now, we have a forum that brings together heads of wordings, senior counsel from across those insurance and reinsurance companies to develop the IUA clauses that are issued with that IUA code. We've got about 26 member companies on the group at the moment. I think a little more than 6 broking representatives actually now, which provides some excellent balance during our drafting discussions and the drafting process. And we do quite a bit of work with the risk manager community, liaising through AIRMIC, which is really valuable in supporting our drafting process. Now, where can you find these clauses? Well, they're all accessible on the IUA clauses library. You can find that online. The clauses are all searchable, easily accessible, and as well as IUA clauses, you can find some joint marine and aviation clauses on there if you're looking for those. So our agenda today, I mentioned that we'll be looking at case law developments over the last year or so, really 3 key parts. So the Insurance Act 2015, scope of cover and policy construction, and then 2024-25 COVID-19 BI decisions. So plenty to get through. Now, our speakers will be looking primarily from an English law perspective, which is important to bear in mind. And I'll introduce you to the 3 speakers now. So we have Chris Crane, Legal Director at Wikborg Rein, Carrie Radford, Carrie's VP Underwriting Counsel at RenaissanceRe, and then Mike Allan, Head of Wordings at Convex. And Mike will be getting us started with the first section of the presentation, looking at the Insurance Act 2015. So I'll hand over to Mike now.
Thank you, Tom. And good morning, everybody. So I am going to kick off by talking about some recent case developments in relation to the Insurance Act 2015. Now, just to quickly recap, the Insurance Act has been in force for a number of years now. It reformed the law relating to non-consumer insurance contracts, and in particular, it replaced the duty of disclosure with the duty to make fair presentation, and it modified the effect of breaches of condition, precedent, and warranties. And in doing so, it addressed some aspects of the existing law, which had been regarded as unduly favouring insurers and unfairly penalising policyholders. who might lose cover as a result of what they regarded as a minor non-disclosure of facts or a technical breach of a term, which was unrelated to the loss for which they claimed an indemnity. So in short, there was a general feeling that sometimes the punishment didn't fit the crime, and so that led to the Act. So interestingly, there has been very little in the way of case law regarding the Act and interpreting its provisions until last year, but there has now been some action. So I'm going to look at three cases which considered the Act over the previous 12 months. First of these is Lonham versus Scotbeef. It's a case which went to the Court of Appeal earlier this year. This case considered the relationship between pre-contractual representations and warranties and conditions precedent. Now, one thing the Insurance Act ended was the practice of insurance companies of turning pre-inception representations into warranties, and by stating that they form the basis of the contract, or using similar words to the effect that the insured warranted the accuracy of all pre-inception representations. And doing this allowed insurers to decline cover for breach, whether or not a representation had actually induced the underwriter to write the risk, or whether there was any causal relation between the breach and the loss. So a very draconian remedy was made available to insurers. Section 9 of the Act provided that they could no longer do this. Now, the facts of this case involved Scotbeef, a meat producer which used refrigeration facilities which were provided by the insured, D&S Storage. In October 2019, a consignment of beef which was being stored by the insured was found to be contaminated with mold and had to be destroyed. So Scotbeef brought a claim for the value of the beef at just under £400,000, and D&S went into insolvency, and so Scotbeef pursued its claim against D&S's liability insurers, Lonham Group, under the Third Parties Rights Against Insurers Act. Now, the key term of the policy around which the dispute resolved is on the slide. It was a duty of assured clause, and it said that the insured would make a full declaration of all its current trading conditions to insurers, that it would trade under those conditions throughout the duration of the policy, and that it would take all reasonable and practicable steps to ensure that the conditions were included in all of its contracts with companies like Scotbeef. Now, what happened in practice is that the insurer started off trading with clients on its standard terms and conditions, and importantly, they limited any liability it might have to a customer to £25,000. But unfortunately, at some point before the consignment, which was the subject of the claim, it had stopped incorporating the terms and referring to them on its invoices. And at a trial of a preliminary issue, the High Court found that the terms and conditions hadn't been incorporated into the relevant contract. So insurers latched onto this and said, well, look, terribly sorry, but we're declining cover on the basis that you've breached a condition precedent, or alternatively, a warranty contained in the duty of assured clause. So far, so good. Scotbeef didn't take this line down, and it pursued its claim in the High Court. When the High Court came to interpret the duty of assured clause, things got a little bit complicated. The High Court judge looked at the clause and said, well, we have to construe the whole clause together. And that means that all three limbs of this clause are either representations of fact or warranties. And looking at subclause 1, the judge said, well, this is clearly a representation, a made pre-inception. And because all three limbs have to be read together, it follows that subclause 2 and subclause 3 are also representations made prior to inception as to how the insured is going to conduct its business during the period of cover. And so while the court accepted that there had been a misrepresentation and that the terms and conditions hadn't been incorporated into the relevant contract, it said that the condition precedent words in the clause wrongly sought to turn these what it regarded as pre-contractual representations into warranties, and it said, well, look, Section 9 of the Insurance Act expressly prohibits this, so I'm going to disapply this clause insofar as it might be a condition precedent or a warranty. At this point, alarm bells are well and truly ringing in the insurer's legal camp, and the judge carried on to say that your only potential remedy is for a misrepresentation, and unfortunately, there's no evidence before the court to say what you would have done had a fair presentation of the risk been. And on that basis, you can't avoid the policy and no other remedies available to you. So Scott Beef, insurers were unable to decline cover, and Scott Beef was free to proceed for the full amount of £400,000. Now, as you can imagine, this caused a bit of a stir in the insurance market, particularly amongst casualty underwriters, and this is because it cast doubt on the ability of underwriters to control the nature and extent of risks through appropriately worded warranties and conditions of the policy. That being the case, the insurers appealed to the Court of Appeal. I should just say that the illustration on the slide is a casualty underwriter reading the first instance judgment, and that was pretty much my reaction when I read it too. The Court of Appeal reviewed the first instance decision, and it said, well, the lower court incorrectly concluded that all three of the subclauses have to be pre-contractual representations because Clause 1 was a pre-contract representation. There's no rule of construction that says that supports that approach. Subclauses 2 and 3 were plainly future warranties, which regulated the insurer's conduct during the policy term. And there's no reason why the duty of assured clause can't impose different duties to which the insured is subject at different times in its trading relationship with Scott Beef. The clauses were also found to be conditions precedent, for the simple reason that the clear wording of the policy stated that they were. And this meant that Section 9 actually had no relevance. And by failing to trade on the standard terms and conditions, the insurer was in breach of warranty and breach of condition precedent, and therefore there was no cover. And it was that straightforward. Now, in reaching that decision, the Court of Appeal regarded as particularly significant the fact that the clause included the heading general conditions was included under the heading general conditions, exclusions, and observances. The clause itself stated that it was a condition precedent to cover. The clause was described as a duty of assured clause, and the word duty is synonymous with an ongoing obligation. And finally, the policy contained wording to the effect that breach of condition precedent would have the consequence that insurers are entitled to avoid the claim in its entirety. So there was no real ambiguity there either as to how the term was intended by the parties to operate. So what do we take away from that? Well, I think the primary takeaway is that provided a term is clearly stated to be a condition precedent or warranty, it should be construed as such. But it's very important that it's clearly drafted and labelled, and that the words condition precedent or warranty are used in the clause. It's also very important that you state what the consequence of breach is going to be, ideally in the clause itself. And there's another point to take away, which is more of a life lesson, which is if you go to trial, you really do roll the dice, and you might encounter a judge who sees things from a very different perspective yours, or just gets things plain wrong, which is what happened in this case. Okay, my second case is MOK Petro Energy versus Argo. And this case is significant because it's the first one to consider the application of Section 11 of the Insurance Act. Section 11 is the part of the Act which moderates the effect of breach of condition precedent or warranty, and it provides that insurers can no longer rely on a breach of warranty or condition precedent to decline cover for a loss if the insured can show that breach of the term in question couldn't have increased the risk of loss in the circumstances in which that loss occurred. So it's introducing a form of causation test. It's not a standard. It's not the standard test for requiring approximate relationship, but there needs to be some kind of connection between the breach and the loss. The facts of the case were involved a shipment of a blend of gasoline and methanol, which were loaded onto a vessel from separate shore tanks in Oman and mixed in that vessel's tanks. While the mixture was certified to be on specification in Oman, when it arrived at its destination in Yemen, it was found to be off specification and unmarketable. And the finger of blame was directed at contamination with water when the constituent parts of the mixture were loaded onto the vessel in Oman. So reinsurers declined cover, and the MOK pursued the reinsurers under a cut-through clause in the direct policy. Reinsurers declined cover on the basis of breach of the survey warranty, which was contained in the policy, and it stated that it required both inspection and certification of the cleanliness of, amongst other things, of the connecting pipelines between the vessel and the shore tanks at loading and at discharge. And in fact, what had happened is that while an inspection had been carried out by an appropriate marine surveyor at the loading port, that inspection had not been certificated. And the reinsurer said, well, sorry, the survey warranty has been breached, and so any claim under the policy is precluded. MOK said, well, hang on, the breach only related to a failure to get certification. And that's a discrete obligation under the warranty. And what's more, getting a certificate wouldn't have reduced the chance of contamination occurring. A certificate is just a piece of paper. It wouldn't have made any difference. And therefore, applying Section 11 to these circumstances, you cannot rely upon this technical breach of warranty to exclude cover. So the case went to the commercial court, and the judge who heard the case said, well, sorry, Section 11 requires a broad inquiry. You have to consider the warranty clause as a whole, and he regarded it as completely artificial to try and separate the obligation to inspect and then the obligation to certify that inspection. He said these are codependent on each other. You can't. An inspection has no real value if you don't certify what you found, and you can't issue a certificate unless you've actually carried out the inspection. So he regarded those two as inextricably linked, and he said, furthermore, there's nothing in Section 11 to suggest that where a term of the policy can be breached more than one way, it's only the particular breach which has to be looked at. You have to look at the clause as a whole and ask the question whether failure to comply with the entire clause would have increased the risk of loss in the circumstances in which that loss occurred. And here, there is no real dispute that compliance with the warranty as a whole would reduce the risk of water contamination. So reinsurers were fully entitled to rely on breach of warranty as a defense to the claim. So in circumstances like this, a technical breach of part of the warranty is going to be sufficient to avoid cover, provided that breach is inseparable from the rest of the warranty. So the key question, as always, is will failure to comply with the entire warranty tend to increase the risk of loss. Right, on to the third case. This is Tunfield Care versus New India Assurance. Now, as I mentioned at the start, the Insurance Act replaced the duty of disclosure with a duty to make fair presentation of material circumstances. So what does that mean? The insured is under a duty to make a fair presentation of the risk by making sure that material representations it makes in response to questions are substantively correct, and that it has to disclose all material circumstances to the underwriter that it's presenting the risk to. So if an underwriter wishes to sort of considers there's been a breach of the duty and that he should be entitled to remedy, he has to do two things. He has to establish that the insured has made a material misrepresentation or has failed to disclose a material circumstance. But he also has to show that there's a qualifying breach under the Act. And to do that, he has to show that if he had been aware of the material circumstance, he would not have written the policy at all, or he or she would only have written it on other terms. And those terms will apply from inception. So the facts of this case were that an insurance policy had been taken out by a group of companies which owned and ran care homes. Following a fire at one of the care homes, the insurers claimed under the policy, and then insurers sought to avoid on the basis of misrepresentation or non-disclosure. And that was on the basis of the question contained in the proposal form, which is on the slide. And this asked them whether any director or partner had ever been declared bankrupt or had been a director of a company which had gone into liquidation, administration, or receivership. In response to that question, the insurer had answered no. But it became clear that the insured, and the insured accepted this was the case, that Mr. K, who'd not been listed as a director at Companies House for certain of the material periods in question, had been a shadow or de facto director of all of the insured companies at all material times. And to compound this, Mr. K had also previously been a director of a fashion retail business, which had been placed into administration in 2006. So insurers looked at this and said, well, we're afraid this places a completely different complexion on things. Your answer no to that question was a misrepresentation, material misrepresentation, and your failure to tell us that Mr. K was actually running the businesses as a de facto director, and what's more, had a history of insolvency. Had we known with the true situation, we'd never have insured you at all, which obviously put the insured in a pretty tight spot. So the insured applied for a declaration that there was cover for its claim and it was entitled to indemnity under the policy, and so that there were two questions before the court. Firstly, had there been a material misrepresentation, and secondly, had there been a non-disclosure of material circumstances. So in response to the first question, the judge said, well, I don't think there was a misrepresentation here. A reasonable person reading the question on the proposal form would have understood that it was directed only in relation to de jure directors. That means, a director at law who, namely a director who's registered as such at Companies House. And it's not reasonable to expect a policyholder like the insured, which wasn't a particularly large or sophisticated entity, to understand that they should have considered whether the question was also addressed to encompass shadow or de facto directors. So on the basis that any reasonable policyholder in the position of the claimant would have understood the question to be being asked only in relation to legal directors, he said there'd be no misrepresentation. The insurer had answered the question honestly in the way that it had understood it. Unfortunately, that's where the good news ended for the insured, because the judge said at the same time, Mr. Kay's status as a de facto director and the fact he was actually running these businesses, and his insolvency history were material circumstances which ought to have been disclosed. And in doing so, he made some important points. The first is that the burden's on the insurer to demonstrate materiality. It's an objective question, but it is assessed by reference to a prudent underwriter, and the threshold for materiality is low. The insurer simply has to demonstrate that a prudent underwriter would have been influenced by the undisclosed facts. So, in other words, that a prudent underwriter would not simply disregard the fact in its entirety, and if that's the case, then the fact is material. So, even so, the insolvency history of Mr. Kay was sometime in the past, and it related to a different kind of business. And Mr. Kay had not been the subject of any adverse comment in the administration. The court accepted that a prudent underwriter would have taken this into account, as it would the fact that he was operating as a shadow director. So the non-disclosure was of material facts, and then the judge said, in relation to whether there has been a qualifying breach, the insurer has to demonstrate that it was induced to act as it did by the material circumstance which wasn't disclosed. It has to show that it wouldn't have written the policy had it been aware of Mr. Kay's role as a shadow director and of his insolvency history. So the burden's on the insurer to prove inducement, but it's the same test as under the old law. It's a subjective, factual question, and that question is, what would this underwriter have done when had it been made aware of these material circumstances? So expert evidence as to what a reasonable underwriter would have done is irrelevant. It's subjective, and based on the underwriter's oral evidence and upon the insurer's underwriting guidelines, which supported the underwriter's position, the judge accepted the insurer wouldn't have written the risk at all had he known of Mr. Kay's role as a de facto director and of his insolvency history. So, having proved inducement, insurers were entitled to avoid the policy in its entirety. So, what do we take from that decision? Well, first thing is that the test for whether there's a qualifying breach under the Insurance Act is essentially the same as the old test for inducement, and the burden is going to lie on insurers to show they would have acted differently had they been aware of the material circumstance. And this leads on to two key things to bear in mind when you're trying to prove inducement. The first one is the in-house lawyer's favorite point, which is it's vital when you underwrite a risk that you record your decision-making process in the underwriting notes. These show exactly what you were thinking at the time the risk was written. And if you don't have detailed notes or notes which record why you did what you did, it's just going to be the underwriter's word. And in the words of Christine Keeler, well, he would say that, wouldn't he? It puts you in a very tight spot. The second is it helps a lot if you're supported by the underwriting guidelines. If the underwriting guidelines don't support you, then you're simply not going to be able to prove inducement. So that is all I have to say about that, and I will leave you with that image of a happy casualty underwriter who now understands the Insurance Act with a bit more clarity. Thank you very much.
Okay, thanks, Mike, and hello to everyone watching. I'm going to use my slot to look at a handful of cases that provided us with some useful insights into how the courts looked at questions of scope of cover and policy construction. apart from Project Angel Bidco, these cases all relate to different forms of property cover. So that's just a flag that I will generally be looking at the principles arising from these cases in a property context. I've included the citations of the cases that I will discuss on this slide so that they're there for your reference to look up after the session. Number of cases last year dealt with issues relating to the scope of cover. In other words, whether or not a loss suffered by the insured is covered by the policy. In very broad terms, the scope of cover under a policy is determined by construing the insuring clause together with exclusions and writebacks or extensions. Policy properties often include are often written on an all-risk basis with exclusions for losses caused by certain categories of risks, such as some of the common examples that I've included in the slide, that underwriters do not wish to cover. The insured will then often purchase cover for those risks in separate named perils policies or through a writeback or extension to the all-risk cover. The insuring clause, together with the exclusions, is therefore the foundation of the policy, defining what is and what is not covered. From a policy wordings perspective, it's therefore essential that these terms are as clear as possible and to avoid contradictions and inconsistencies between the excluded perils and the insured perils. A typical insuring clause in a property cover provides, as you can see on the screen, that insurers shall indemnify the insured against physical loss or damage to the property occurring during the policy period. Now, this very common insuring clause raised some interesting issues in the first case that I'll look at, Sky versus Riverston. Now, this was a case about a leaky roof of Sky's gleaming new headquarters in West London, which was caused by defective design work during its construction between 2014 and 2016. During the construction project, and for a year after, following completion, the construction work was covered under a construction all-risk policy. The roof, which is said to be the largest timber flat roof in Europe, comprised hundreds of wooden cassettes placed upon a series of timber beams. Following installation, the main contractor failed to provide a protective roof, which meant that the cassettes were left exposed to substantial rainfall whilst awaiting permanent waterproofing. This allowed water to enter into the cassettes, causing serious wetting of the timbers, swelling, and structural decay. Over time, and crucially, after practical completion of the construction project and after the expiry of the policy period, the moisture spread and the condition of the wooden cassettes continued to deteriorate, which then required major remediation works. Sky, along with its main contractor, bought claims under the CAR policy, which provided, as mentioned before, for cover against physical loss or damage occurring during the policy period. The insurers disputed Sky's claim on a number of issues, but the two that are most interesting for the purposes of this presentation are what is the meaning of the term damage in the insuring clause? Is wetting of the timbers sufficient? Or do they need to have reached such a condition that requires their immediate repair or replacement, as the insurers had argued? And does the scope of cover include deterioration or development damage that occurred after the expiry of the policy period? In the commercial court, the judge had found that damage required change to the physical state, which rendered the insured property either less valuable or of less utility. The presence of water or moisture in cassettes would adversely affect their stability, strength, functionality, or usable life if they were left unremedied, and therefore on that basis the timber had suffered physical damage within the meaning of the policy. But the commercial court at the time found that the policy only covered damage as it existed at the end of the policy period. So it didn't cover remediation of the substantial deterioration that occurred after the expiry of the policy period. On appeal by both parties, the Court of Appeal found in favour of Sky on all practical issues. Firstly, it upheld the decision that the wetting of the timbers in the roof, even if capable of remediation by drying out, constituted damage on the natural and ordinary meaning of the word. And secondly, it overturned the commercial court's decision on development damages, finding that Sky was entitled to the costs of remedying foreseeable deterioration caused by the wetting of the timbers. Now, the Court of Appeal's reasoning on this second point is interesting, as it goes to the very root of what a contract of insurance is. It held that a contract of insurance against damage to property is a contract of indemnity, which is often described as a contract to hold someone harmless, in the sense that the insurer promises that the assured will not suffer the insured damage in the first place. If and when the insurer fails to perform the primary obligation, i.e. the damage occurs, it comes under a secondary obligation to pay damages for breach of the primary obligation. As a result, a property insurance is not, therefore, a claim to enforce a promise to pay money, as most people may think, but a claim for unliquidated damages. The consequence of this is that the measure of recovery in a property insurance claim is determined by common law principles governing damages for breach of contract, which include causation, mitigation, and remoteness. And so, subject to express policy terms such as limits, deductibles, valued policies, and exclusions for certain kinds of loss, such as consequential loss, the measure of loss in a claim for damaged property will therefore generally be the sum of money that's required to repair the property to the condition it would have been in if the damage had not occurred, which includes, in this case, the costs of remedying foreseeable deterioration and development damage that occurred after the expiry of the policy period, but had resulted from insured damage that occurred before the end of the policy period. The insurers have filed an application for permission to appeal to the Supreme Court, so it'd be interesting to see if the Supreme Court hears the appeal and whether or not it agrees with the Court of Appeal's analysis on the contract of insurance as a contract of indemnity. And moving on, one of the themes of last year was a series of cases in which the court confirmed and applied principles of policy construction to determine coverage disputes where parties have different interpretations as to the meaning of terms. We've outlined 3 cases in the next slide, but we thought that it may be helpful to try and distill and summarize the principles that the courts applied. So where there are competing policy terms, the exercise carried out by the court is to ascertain what the objective intention of the parties was at the time of entering the policy. And it does this by considering what a reasonable person who has all relevant background knowledge available to the parties would have understood the language used in the policy to mean. Does this by focusing on the meaning of the words in their documentary, factual, and commercial context. That meaning has to be assessed in the light of the natural and ordinary meaning of the words. That's the primary and overriding factor. Where parties have used unambiguous language, the courts must apply it. This is because, unlike commercial common sense and surrounding circumstances, the parties actually have control over the language that they use. The court will look at the policy as a whole and other relevant provisions in the policy to assess the overall purpose of the clause and the policy. And where the natural meaning of the words is clear, the court will find it hard to justify departing from them, even if it might lead to unexpected results. But the courts have acknowledged that the less clear that the words are, or perhaps the worse the drafting of the policy, the more ready the court may be to depart from their natural meaning. So in that case, the court may move from the pure textual approach to apply a contextual approach. As part of the exercise, the court may consider facts and circumstances known by the parties at the time the policy was entered, but crucially not evidence about what the parties subjectively intended or understood, and also not facts that were only known to one of the parties. Where there are two possible constructions, the court is entitled to prefer the construction that is consistent with business common sense. However, commercial common sense should not be invoked retrospectively, and the court should be very slow to reject the natural meaning simply because it appears to have been an imprudent term for one of the parties to have agreed. It's also well established that the court will not retrospectively undo what is essentially just a bad bargain for one of the parties. So the key takeaway really is that the drafting is paramount. The courts will first and foremost apply the textual approach to apply the natural and ordinary meaning of the language used in the policy, and the courts will only apply a contextual approach and other factors if the textual approach does not provide a clear answer. So turning to the cases, in Project Angel Bidco, the Court of Appeal construed an exclusion in a warranty and indemnity policy. As a reminder, warranty and indemnity policies provide cover for purchasers of businesses against losses caused by breaches by the sellers of the representations and warranties provided in the sale and purchase agreement. In this case, the policy consisted of two documents, the main policy wording and an appendix which listed the insured obligations, namely the warranties that were included in the sale and purchase agreement. The appendix indicated that various bribery and corruption related warranties in the sale and purchase agreement were covered, but an exclusion clause in the main body of the policy excluded loss arising out of any liability or non-compliance in respect of anti-bribery and anti-corruption laws. The insured argued that something must have gone wrong with the wording because, on a plain reading of the exclusion, any claim for breach of the bribery and corruption warranties would always be excluded. But the warranties were expressly noted as covered in the appendix. The court concluded that the apparent contradiction between the appendix and the exclusion did not mean that there had been an obvious error. The appendix listed the prima facie scope of cover granted, while the exclusions then acted to restrict cover in certain circumstances. There's nothing unusual about that, even if it meant in practice a breach of the bribery and corruption warranties would never be covered. On the plain terms of the policy, the claim was excluded. The Court of Appeal took a similar approach in Bellini and Britt, a claim for COVID-19 business interruption losses under a murder, suicide, or disease extension. The insuring clause in that case was very similar to some of the disease clauses considered in the FCA test case, apart from it expressly provided that coverage was contingent upon physical damage. It was common ground that there had not been any such damage and the insurer denied cover. As in Project Angel Bidco, the insured argued that something must have gone wrong with the language, because if damage was needed, then for all intents and purposes, the coverage created by this clause would be illusory. Court of Appeal rejected this argument as an attempt to push the boundaries of correction by contractual construction too far. Construing the insuring clause objectively in its wider context, the damage requirement was clearly deliberate. The fact that the cover was consequently quite limited did not make it absurd and did not justify rewriting the contract. Court of Appeal reiterated that where parties have used unambiguous language, the court must apply it. In Technic and Medin Gulf, Technic was one of the insureds under a composite offshore construction policy for construction works to offshore assets in Saudi Arabia, owned by KJO, who were also an insured under the policy. Technic had chartered a vessel to perform some construction work under the contract, but the vessel collided with an existing wellhead platform, which was owned by KJO, and caused significant damage to that platform. Technic claimed for the sums which it was liable to KJO in relation to damage caused by the vessel. However, the insurer denied liability on the basis that there was an endorsement that excluded liability for damage to existing property owned by the principal assured. Technic argued that the exclusion only applied to property owned by the assured making the claim, whereas the insurers argued that it applied to property owned by any of the insured parties. Whilst the Court of Appeal recognised that the policy was not a model of clear drafting, it upheld the commercial court's judgment in favour of the insurer's interpretation. In doing so, it said that Technic's construction did far more violence to the natural meaning of the words, and noted that the insurer's construction was consistent with the commercial rationale of the policy. So moving on, in the live presentation that we ran earlier this week, we looked at a case study which was adapted from a case in the commercial court last year, which construed the insuring clause and an exclusion to determine the scope of cover under a political violence policy. The facts were that the insured owned and operated a warehouse in Afghanistan. In 2021, US forces withdrew from Afghanistan and the warehouse was seized by the Taliban. The insured lost possession and control of the warehouse and claimed its political violence under its political violence policy, which provided cover for, amongst other things, physical loss or physical damage caused by act of terrorism, sabotage, civil commotion, rebellion, and/or war. Policy excluded or included an exclusion against loss or damage directly or indirectly caused by seizure, confiscation, or expropriation of any insured property, nor loss or damage by law, order, or regulation of any governing authority. The insurers argued that the loss was excluded because it was caused by seizure, whereas the insured argued that the exclusion did not apply because the seizure must be by a governing authority which did not extend to the Taliban. So we asked the audience to decide whether they thought there was cover, and the answer was no. The scenario was a slightly simplified adaptation of the facts in Hamilton versus Afghan Global. In that case, the court found in favour of the insurers applying the principles of policy construction that we looked at before. Here, there was no question that the loss of the warehouse was caused by its seizure by the Taliban. The exclusion clause was unambiguous and excluded any loss directly or indirectly caused by seizure. The judge rejected the insured's arguments that the seizure must be by a governing authority and held that the word seizure should be given its ordinary and natural meaning. Settled precedents have established that the word seizure covers all acts of taking forcible possession either by lawful authority or by overpowering force. A sophisticated insured, acting in this case by and with advice of specialist brokers, should have understood the ordinary and settled meaning of the term as confirmed by previous case law. In addition, looking at the policy as a whole, it was clear that the policy only covered physical damage or destruction and not loss by deprivation of possession. The natural and ordinary meaning of damage required some altered state, and there had been no change in the physical state of the warehouse. I'll finish with some key takeaways from these cases. If there's one point that I would emphasize above all others, it's that clear drafting is always key, as the court will look at the language of the policy first and foremost and look to give it its natural and ordinary meaning. It's only if the textual approach does not provide clear answers that other factors such as commercial common sense come into play. So wherever possible, aim to keep the drafting as clear and simple as possible so that it clearly reflects your intent and understanding of what you are covering and not covering. And with that, I will hand the baton over to Carrie.
Thanks very much, Chris. Just adjust my settings. Hi, everyone. Well, no discussion of the 2024 insurance law decisions would be complete without looking at the COVID-19 business interruption cases. And so I am going to focus on a number of those cases during this session. On the slide, you have a list of at least most of the decisions of 2024 and 2025, and you can see from the blue text that these cases grapple with a number of different legal issues with a good amount of overlap. Like the cases that Chris has talked about, the cases look at what the policies provided cover for in the insuring clause. They discussed in some cases during what period the losses insured against had to manifest themselves. That was particularly an issue in and several of the cases addressed differences of opinion between the insurers and the insureds over the limit of cover and whether it applied once in respect of all of the losses suffered or suffered by all of the insureds, or whether it applied multiple times to each insured premises or named insured. I am going to speak in particular about the cases which are represented by the pictures on this slide. So first of all, the XL case against Allianz. I am also going to speak about the causation, the XL case that focuses on causation and the meaning of the causation test. I'm also going to talk about the various eateries case, sort of more or less alongside the Bath racecourse case, as both of those involved different kinds of disputes over the application of the policy limit. So before jumping into the more recent cases, it's helpful to have two pieces of background in mind. And this slide points to, first of all, a very sort of vanilla definition of business interruption insurance. So at its most basic, business interruption insurance provides cover for loss of operating profit caused by loss of income and or increase in costs as a result of physical damage to the insured property. Very often that basic cover is supplemented by extensions, for instance, for business interruption losses caused by physical damage to an adjacent property, or perhaps physical damage to a supplier's property. The COVID cases look at another common extension, and that's for BI losses caused by prevention of access to an insured premises as a result of an incidence of a notifiable or contagious disease. And the second piece of background then is an overall awareness of an understanding of the FCA test case decisions. So the FCA and Arch test case was heard in the High Court and the Supreme Court in 2020 and 2021, and it looked at a number of London market business interruption clauses and decided whether they provided cover for losses suffered by the nationwide outbreak of COVID-19 and the lockdowns imposed by the government in response. And the Supreme Court decided that the policies did provide cover for business interruption losses, and they looked at three different types of clauses. They looked at disease clauses, which covered business interruption losses where there was an occurrence of disease in the vicinity of the insured premises, often within a particular radius. They also looked at prevention of access clauses, which required the insured premises to be inaccessible as a result of government or local authority action. And also hybrid clauses were the third type that they looked at, which required a combination of a disease clause and a prevention of access clause. So an incidence of disease in the vicinity of the insured premises, giving rise to a local authority or government action creating prevention of access to premises. So one of the disease radius clauses that the FCA test case looked at is on the slide with the key part. So it said, we shall indemnify you in respect of interruption or interference with the business during the indemnity period following any occurrence of a notifiable disease within a radius of 25 miles of the premises. And the graphic illustrates the Supreme Court's finding that the BI losses suffered by the insured were caused by COVID-19, and they were caused by the COVID-19 cases that occurred within the relevant radius, as well as being caused by the cases that occurred outside of the specific radius. The insurers had argued that that was not the case, and that the causative link between the insured peril and the loss required by the policy wording wasn't met. They said that each individual insured's loss was not proximately caused by the local COVID cases, but rather it was caused by the pandemic as a whole. In other words, they said, but for the local cases, the insured would still have suffered the same business interruption losses as a result of the national lockdown, and consequently, they said there should be no cover under these disease radius clauses. But the court rejected that because this interpretation could be expected in many cases to deprive the insured of the cover it had bought. And bearing in mind that by their very nature, infections spread, and therefore cases are likely to be found both within and without a given radius. Instead, the court found that every individual COVID-19 case was a concurrent proximate cause or an equally effective cause of the lockdowns, and therefore of an insured's business interruption losses. And following on from Chris's reminder about the cover being found in the combination of the insuring clause and the exclusions, it's helpful also to remember that under English law, if a loss is concurrently caused by an insured peril and an excluded peril, then there'll be no cover. And by contrast, if a loss is caused by both an insured peril and a peril that is not insured but that is not excluded, then there is cover following the Miss JJ and the Wayne Tech decisions. And this FCA decision is an example of the latter. So there was a finding that the individual losses were caused both by the insured peril, the incidence of disease within the radius, and also an uninsured peril. They were concurrently caused by incidences of disease outside of the specified radius. So coming on then to the 2024 cases, in the Court of Appeal decision in London International Exhibition Centre and Allianz, the court considered whether there was cover for BI losses suffered by insureds whose insurance policies provided cover for business interruption losses on at the premises terms. So the slide provides an example of this wording, and I've tried with the colours to highlight all the different elements of one of these clauses. So actually starting from the green towards the end of the clause, there was a requirement in the insuring clause that if there is an outbreak or an occurrence of any human contagious or infectious disease at the premises, as a result of which there's an order or advice of any local or governmental authority, and as a result of that, that requires a closure of the premises or part thereof. So that's a typical ATP clause, which the court was looking at. Insurers said that an ATP clause like this is totally different from a radius clause of the kind that was considered in the FCA test case, because the latter only required a case at some distance from the relevant premises, and that naturally contemplated that there might be other cases outside the specified radius. Similarly, the other types of cases that the Supreme Court looked at necessarily anticipated cover being provided in scenarios where there was a spread of disease. Therefore, counsel for the insurers in the XL case said that the FCA test case made sense, but they said that it shouldn't apply to an ATP wording because that provided cover only where losses were suffered as a direct result of the operation of the insured peril at the premises. And they pointed to the fact that the ATP clauses provided cover for very localised perils, not only infectious disease incidences, but also often in the same clause, presence of vermin or food poisoning or an issue with sanitation. The Court of Appeal did not agree with the insurer's construction, though, and they upheld the High Court's decision and applied the same concurrent proximate cause analysis as the Supreme Court had in the test case. They rejected the causation arguments from the insurers that ATP clauses required a closer causative link between the peril and the loss than proximate cause. The argument being that for there to be cover, the loss had to have been caused only by the insured peril. And in rejecting that argument, the court thought about the nature of the relevant insured peril, here the occurrence of a contagious disease, and they concluded that if the insurer's formulation of the test was correct, then it would likely deprive the insured of the benefit of the cover. That wouldn't make sense, and so it couldn't be the correct reading of the causation test. And in so deciding, the judges used this great line, "Such occurrences come not in single spies, but in battalions." And that was the inspiration for my shades-wearing, terrible plague-hatted figure. By analogy, the court also reasoned that the insurer's interpretation of the clause, permitting cover only if the occurrence of the disease was at the premises, was either the exclusive or at least a clear discernible cause of the closure order, would produce arbitrary and unfair results. And they gave, as an example, the closure of a row of restaurants in response to a number of known cases at some of those restaurants. They said if the insurer's causation test was right, then only those restaurants which had had confirmed cases of disease at their premises before the closure order was made would be able to claim on their ATP insurance. The other restaurants, assuming they had identical ATP cover, would not be able to claim, even if they found out later that in fact at the relevant time there had been confirmed cases at their restaurants too, that they just hadn't been in the contemplation or in the knowledge of the decision makers giving rise to the closure order. And the court said there was no logic or sort of defensible logic to that outcome. So the key points to take away from the XL case are twofold, I think. Number one is thinking about exclusions. If, as an insurer, you only intend to provide cover in narrow circumstances, especially if you want to avoid providing cover in more of a systemic loss scenario, where arguably loss might have been suffered in any event owing to a wider insuring peril operating, then consider using exclusions to make that clear. In relation to causation, bear in mind that the nature of the cover, so what is being insured against, will inform the strength of the causative test required between the insured peril and the loss suffered on the basis of these cases. And we've seen that English law won't support an argument that the necessary causative link between the insured peril and the loss needs to be so strong that it's unlikely ever to be met. And that's because the court is trying, within the words of the contract, of course, to bring about the outcome that the parties would have contemplated when negotiating the cover, taking into account the nature of the insured peril then, and the circumstances in which that insured peril would be expected to operate and the cover would be expected to be needed. Turning to the second 2024 decision I'm focusing on in various eateries and Allianz, the insured chain of restaurants, which was originally the Strada chain, suffered business interruption losses totaling £16 million across all of its sites. And this time it was accepted that there was coverage, but the issue that was in dispute was about aggregation. The dispute was about how much cover was available, where the policy limit of £2.5 million for business interruption losses applied per single business interruption occurrence. And the exact wording is on the slide. The limit applies to all business interruption losses that arise from, are attributable to, or are in connection with a single occurrence. The case was originally heard in the High Court alongside two other cases also brought by the Stonegate pub chain and Greggs. And in a lengthy judgment on aggregation handed down in 2022, Mr. Justice Butcher held that the single occurrence from which all of the BI losses suffered by the restaurant, pub and shop chains across the country arose from, were attributable to, or were in connection with, was the government action in closing hospitality venues, first made on the 21st of March and then revised on the 26th of March 2020. And insofar as there were distinct government orders that were made after that date, which did more than merely modify a previous one, the policy limit would apply in relation to the losses. In reaching that conclusion, the Court of First Instance found that the original transmission of COVID-19 to the human population in Wuhan also amounted to an occurrence within the meaning, being something that occurs at a particular time, at a particular place and in a particular way, and that the causation language in the aggregation clause, so arise from, attributable to or in connection with, was wide enough language for the business interruption losses to have been caused by that alternative occurrence definition. However, Mr. Justice Butcher held that the outbreak of the disease in Wuhan was too remote from the hospitality losses that had been suffered by the UK companies for that alternative occurrence to be relevant. In the Court of Appeal then, where we had the decision handed down last year, the insured and the insurers both appealed. The insured appealed on the basis that the commercial court had been wrong to reject their argument that the policy wording provided cover per occurrence and also per insured location. And on that point, the Court of Appeal in various eateries looked both at the language of the aggregation clause, then at the language of the wider context, the wider policy wording, and then they looked at the authorities, and they said on the words of the clause specifically itself, the words didn't say that the losses should be aggregated by occurrence and by insured premises. And then looking at the wider policy language, the court found support for their conclusion by the fact that there was language to the effect that the retention would only apply once in respect of all affected sites in case a single business interruption occurrence affected multiple insured establishments. So there seemed to be language elsewhere in the policy wording that anticipated that you could have an occurrence which would affect multiple sites. And further, the court then addressed the authorities that it had been referred to, and specifically it referred to the decision in another COVID case in Corbyn and King and AXA, one of the many authorities it looked at, but it said that that particular decision was not relevant to its decision. In that case, it had been held that there was a presumption that a policy limit applies per insured, but that case concerned a composite policy, whereas here each restaurant that suffered losses was owned by the same insured entity, and we'll look further at composite policies in the final decision. So, as I said, the insurers also appealed the High Court decision, and they did that on the basis that the judge had wrongly applied the remoteness test in finding that the outbreak of disease in Wuhan was not the relevant occurrence. They said that in connection with, in the aggregation clause, only required a weak link between the occurrence and the losses, and that should have been taken into account in permitting a greater degree of remoteness between the occurrence and the losses. The Court of Appeal rejected the insurer's appeal too, it agreed that the remoteness principle should be applied with less rigour and greater flexibility, where the aggregation clause only requires a weak causal link between the occurrence and the losses. But even so, the principle still required that the unifying factor, or the occurrence, should be a significant event which provided a meaningful explanation for the loss. And the court said they didn't agree that so saying meant that they were, in effect, requiring there should be a proximate cause between the occurrence and the loss. They went on to say that the court would be less likely to find that an event or occurrence that was remote in time or place from the losses would be an appropriate occurrence. And similarly, that where there were a series of intervening events between the proposed occurrence and the losses, then again, that would tend to suggest that a competing occurrence was too remote to be the relevant one. In terms of the learning points to take away from this case, it's difficult to say whether an aggregation clause that permits a broader aggregation of losses will turn out to be more favourable to an insurer or vice versa, because aggregation wording can always go either way, depending on the facts of the scenario. What is important, though, is to try to minimise the scope for uncertainty and disagreement. And a good way to do that is by testing your clause to consider what it would require in a hypothetical extreme scenario or scenarios. So as an example, if a policy provides cover for multiple locations, be very clear about whether the coverage limit should apply per location or to the losses of the overall insured entity. So from an insurer, it's really key to understand to what extent a more systemic loss creates sideways exposure, so the same limit being applied multiple times to the same wide occurrence. And from an insured's perspective, it's key to understand whether or not you've bought enough cover, depending on the outcome of that kind of a test. Final case that I'm going to talk about as part of this presentation, that of Liberty and Bath Racecourse. So the Court of Appeal gave judgment in this case in February 2025, in fact, and the insureds were three separate group companies operating a variety of venues, hotels and small businesses, all of which had to close their doors during COVID. The business interruption insurance policies were prevention of access wordings, providing cover in case of government action preventing or hindering access in consequence of a danger or disturbance in the vicinity of the insured premises. The first issue on appeal was whether furlough payments received from the insured, by the insureds from the government for up to 80% of their wage bill had to be deducted from their recoverable losses under their BI insurance. And the slide sets out one of the savings clauses considered, which was part of the overall clause detailing the calculation of the BI losses. So it says, if any of the charges or expenses of the business payable cease or reduce in consequence of the damage, such savings during the indemnity period shall be deducted from the amount payable. And the parties agreed that damage in this clause meant the insured peril. So during the live session of this talk, I asked the audience to think about whether they thought that the court would find that the furlough payments should be deducted from the business interruption losses or not, and think about that both as a matter of construction of that savings clause and as a matter of principle. And the answers were yes or no. So yes, in saying that, you would be thinking about the fact that the government furlough payments had the effect of reducing the insured's costs and so improving its net position, and they've been paid in consequence of COVID, and therefore they ought to be taken into account. Alternatively, you might think that no, they shouldn't be taken into account because the furlough payments weren't a direct reduction in the insured's costs, and they were more of a rebate, and they weren't really caused by the causation wasn't really there, because the reason for the furlough payments was the government intention or rationale in wanting to avoid mass unemployment. So it was more kind of economically driven. So the correct answer was yes. The Court of Appeal did find that the furlough payments should be taken into account in calculating the overall losses. And the appeal was highly focused on the wording of the savings clause. Both sides made arguments about whether applying the natural English language meaning of the words, as Chris was saying, the furlough payments did cease or reduce. And also they looked in detail and thought a lot about this in consequence of language again, so the causation test. Counsel for the insureds argued that the insurer's more textual or purposive construction required an artificial or a strained reading of the words, but ultimately the court wasn't persuaded by the more semantic arguments, and they found that as a matter of commercial and economic reality, furlough payments were savings, as described in the policy provision, and they were caused or in consequence of the relevant insured peril. So just as individual instances of COVID were each an effective cause of the Prevention of Access Order, so they were each an effective cause of the government furlough scheme introduced to alleviate the economic impact of the pandemic. The Court of Appeal also said that it was appropriate to think about the meaning of this clause from a perspective of principle, being that insurance is a contract of indemnity. And they said that you would need very clear words to for it not to be appropriate to take a kind of cornerstone principle like that into account. They further considered whether there was an argument that one of the exceptions to the subrogation doctrine applied, specifically whether the furlough payments were more in the nature of a gift and were not intended to be for the benefit of insurers, but rather they've been made solely for the benefit of policyholders. And the court wasn't persuaded that those arguments could be made out. So it wasn't a sort of scenario that fell within one of the very narrow limits or exceptions to the subrogation principles. The second issue on appeal in the Liberty and Bath racecourse case was whether the policy limit applied in the aggregate to all of the losses suffered by all of the insurers of the policy, or whether it applied per insured entity. Like in various eateries, this question made a big difference to the monetary outcome for the parties, but unlike in various eateries, here the policies were composite policies. And as a reminder, a composite policy is a single document, but it's deemed to contain a whole series of separate individual contracts with each of the named insured individually with their insurer. And the insured's rights under a composite policy are each several. And for instance, it's common to see a provision that any breach of duty by one insured won't affect the rights of a separate insured. There were lengthy arguments on the precise wordings as regards the limits clauses, but Mr. Justice Flo, giving the decision or giving the judgment for the Court of Appeal, was pretty concise on this point. He said that in a composite policy, the limit would apply per insured unless there's very clear wording to the contrary, which he found there wasn't in the contracts in question. And one of the counsel in this case said that were it to be otherwise, then composite policies would be a trap for the unwary. And the decision followed a line of authorities on the effect of composite policies, including that case I mentioned earlier, that of Corbyn and King and AXA, which the Court of Appeal said had been applied, had correctly applied the law on this matter. And the judge said that this conclusion was also consistent with the expectations of a reasonable policyholder, that its limit of cover would not be eroded by the fate of another person or legal entity. And finally, the words any one loss were said to refer to the loss of a particular insured under consideration, and similarly any one occurrence. And that particular language, any one loss and its meaning, is going to be further looked at by the Commercial Court later this month in this same case. In addition, the furlough question, that was the first issue in this case, is also potentially going to go on appeal. I understand that the insureds have applied for permission to appeal on that point too. So this may not be the last word on a Bath racecourse. Key points then to wrap up in relation to this particular case. I think the point about the fallback position in a composite policy is pretty clear, and so I thought I would re-emphasize the point that emerges from several of the COVID-19 cases that I've talked about. And that is that in these cases, the court has emphasized that the policy wording should be construed from the perspective of a reasonable policy holder. And that's in the context of the relevant policies being very much policies which are purchased by small and medium enterprises. And the reason for that is that by construing the policy wording from the perspective of the reasonable policyholder, the court felt that that considers the cover in the way that would reasonably be expected. And you should also bear in mind that this concept, or this direction from which you look at the wording, is equally relevant to understanding and defining the language of the insured peril, and therefore the cover being provided, as it is to looking at the causation language and what it applies. Oh, I said finally, but actually there's one more slide which I won't speak to, but it is available just as a heads up. Chris briefly mentioned the Bellini and Britt case, which focused on the meaning of damage and to what extent damage was an error in the particular wording. And Chris talked about the construction points that were addressed in that case. And then Unipulsi and Covea, another COVID-19 case, which was a reinsurance case. So if you wanted to do some further reading, then those would be other authorities from last year to go and take a look at in the same vein. And I'll hand you back to Tom.
Okay, well, thank you very much, Carrie, and I'll extend that thanks as well to Chris and to Mike. A huge amount of ground to cover there, lots of really important cases, and I'm sure that everybody who's taken the time to listen would agree. You've distilled down many hundreds of pages of judgments there into some useful takeaways for insurance practitioners, so hopefully very helpful for all of those who have listened. So finally, just to say thank you for tuning in. Do look out for the rest of the sessions this year. So we hold them in person in London, and then we record them and push them out via the IUA's YouTube channel. So keep an eye and you'll see those as they're uploaded there. Thanks very much. And yeah, hopefully we'll see you next time around.